My lord, if consider other side, my lord, I'd like to mention item number 9, lordship. Let it may be taken after 2 weeks. A date may be fixed.
Item number 9, you are appearing for whom? For the petitioner?
We have urgency also.
But
Then we'll take it up today. Why you want adjournment?
today,
Huh?
I could not confirm it.
Ah, this matter was in the list.
Due to my,
You wait, we'll see when the matter reaches, you wait.
due to my personal difficulty, class 12,
So mentioning in this match, in case in item number 12 also, he is not feeling well. That is why he left the court because of this illness. So
Item number 12 is connected with 9.
not connected.
Then
He's respondent.
I am appearing on item number 9 for respondent number 12. My senior is representing the case, and in item number 12 also I would like to make mention.
before January, we can't give a fixed date.
Lordship, in the month of January. In the month of January, lordship.
I am suffering because of
Then we'll take it up. Let's see what is the matter. See, you wait, we'll see. Let the matter be called up, then we'll pass an order. Yes.
I would like to mention item number 12, lordship. My senior is not well, that is why he left the court. And immediately after 2 weeks, lordship.
Who's for the other side?
Mukesh Sharma is there. I made a call, but he is not responding my phone calls.
No, if matters are listed, this prayer for adjournment is being made so casually. Somebody doesn't like, he is not in a good mood, something like that.
No, he is not actually not.
What
feeling
kind
well,
of
that is
prayers
why,
are these? The cases are listed, it should be taken up.
Next week, lordship. Next week.
We don't appreciate this kind of. On the prayer of Mr. L. Mohan Lane, counsel for the writ petitioner, this matter stands adjourned for 2 weeks.
Interim order may kindly continue till then.
Made with the consent of the other side, this matter stands adjourned for 2 weeks. Interim order passed earlier to continue. If the other side comes and objects, we'll hear the matter today.
Lordship, I made a call, but he is not responding.
All right.
I will
If he
inform-
comes and
Lordship.
presses for a
Lordship.
hearing, we'll take up the matter.
Lordship.
item number 27. I am for a response number 2, my lord. I have taken the concern of all the parties, my lord. The contempt matter, my lord.
It is it has been listed for orders. What order?
But it's some deliberation because, my lord, the response number 1, my lord, being a IO, my lord. During
Why you're going somewhere?
no, my lord, today I am not prepared, my lord.
Why don't you wait?
Yes.
It'll reach. Don't worry. Yes.
Your lordship.
Yes.
I will mention item number 15, your lordship.
Sorry?
Item number 15, your lordship.
Yes.
Lordship, I'm for the contempt, your lordship.
Hmm.
Lordship, the matter has become infractuous. That has been complied with your lordship.
Who is for the petitioner?
I'm for the contempt.
No, but where is the petitioner's counsel? Petitioner's counsel has to
I'm
confirm
for
it.
the petitioner counsel.
Then you are saying I am for the contempt now? Your name, please?
T. Chetri on behalf of Mr. A. Ganguly, your lordship.
Mr. A. Ganguly, learned counsel appearing for the petitioner submits that the order of this court has already been complied with and therefore nothing survives for decision in this contempt case. Full stop. Taking note of the submission of Mr. Ganguly, this contempt case stands closed as infractious. Yes.
Item 23 of the same, my lord. Order of this court only complied.
Item
23, my lord.
23. All right, you write the name of Mr. H.R. Ahmed, then same order.
Obligation.
Yes.
May I please, your lordship?
Lordship, item 19, my lord.
Hmm.
The petitioner who instructed me not to praise this
Case, my lord.
This is a contempt case.
contempt case, my lord. I may be allowed to withdraw it, my lord.
Why contempt case? How can it be withdrawn? If somebody has violated the court's order, how does it matter what your client thinks? We would want our orders to be complied with.
My lord, then the matter may be reached.
Let it reach, we'll see. Yes.
Maybe, lordship. Lordship, would they consider other side, my lord? I'd like to mention item number 20, my lord.
Yes.
Matter may be adjourned for the day, my lord.
This is a contempt case. Why? You are for the petitioner.
No, I'm for the other side, my lord.
Let the matter be called, we'll pass an order.
Why the limit?
You wait. When the matter is called, we'll pass an order. Yes.
Daily limit for admission, I think 1 and 2.
Wait, please, your lordship. This is quite old matter, my lord.
Yes.
So 2012, this is allocated to 17 matter has come up together two cases.
Mhm.
So basically, it's regarding eviction from the plot of land from the reserve forest, they say. Petitioner staying there from 1975 around from that onwards. So subsequently, the land was required to make a reserve forest. So Lordship kindly come to the order dated 1/11/21, the little details also will be
So
found.
what is to be done today?
What I'm thinking, my lord,
Yes.
since they have also got the records,
Hmm.
it has come for admission. Why not Lordship finish it in one day, let it come up for hearing, so that I also get prepared, he also can argument, make his argument. I talked to him, he said there's no objection. Now I leave to Lordship's my lord. A particular fix, so that again and again it's come. We'll finish for once for all.
So I have called for the records because I seek instructions,
Hmm.
proper instructions not coming, so I have got the whole record. So I'll say with my senior man that will fix.
So the matter should be taken up for disposal.
For
Yes.
disposal.
When? Today?
No, not today.
Why not today?
I also need some preparation because I go through this voluminous requirement. So
I think he shall have to, I can argue that there is no problem, I'm ready. But the
I'll need,
residual lordship, I think this huge record, let him put some flag marks, it will save your lordship's time only. To be very honest, I can prepare argue today, I'm ready. But to save lordship's time, I don't think, it's a huge volume I've seen, he showed me. Put in flag marks, it will be easier for your lordships.
Mr. M. Nath, learned senior counsel appearing for the writ petitioners, as well as Mr. D. Gogoi, learned standing counsel, Forest Department submits that since the records have been received, both these writ petitions can be taken up for disposal at this stage of admission hearing. First up, the learned departmental counsel, however, submits that he is not prepared to argue the matter today, as some time is required to examine the voluminous records. Full stop. In view of the above, and on the request of learned counsel for both the sides, let this matter be listed again for admission hearing on, let it be 8th of December.
The election cases, my lord. There's no election
Election.
case.
Let it be 6th of December,
Make it 15th, my lord.
on 15th of December, 2022.
14th is Thursday.
14th.
Yes,
14th
Thursday.
is not Thursday.
Oh, sorry, that's the 23 list. It's
No,
here,
no,
it's here, it's here, it's here. No, December.
Let this matter. be
15th is Thursday, yes, my lord. 15th is Thursday.
15th
Yes,
as fixed items.
yes. Public, my lord.
Item 3 and 4.
Yes.
My lord, in this case, the petitioner, my lord, he had participated in an e-auction. And for participation, the precondition was that earnest money deposit has to be given.
Mm.
And I'm here before this honorable court because the earnest money deposit has been forfeited and has been retained by them, and that is why I'm before this honorable court. And to state the facts briefly, my lord.
What has happened to the sound? Hmm? I can't hear anything.
I'll try to be a little louder.
Yes. Yes.
The petitioner, my
So
lord,
there are two writ petitions.
there are two writ petitions. They are similar, my lord, relating to the same cause, same issue. That is why they are related.
All right.
The dates are different.
Okay.
Petitioner, my lord, had participated in an e-auction, my lord.
So
Am-
we are
Am I being
today for
audible?
disposal.
disposal is long pending.
Long pending, my lord.
All right. Yes.
The petitioner had participated in the tender, my lord, on 16th of January 2014.
Yes.
And my lord, it was for a grade 1 ROM exceeding 7,500. This is the grading of the pole, my lord.
Hmm.
Now, as
Goel, just 2 minutes. Just take your seat for 2 minutes.
my lord.
All right, let us see clause 9 of the e-auction scheme 2007.
Yes, my lord, at annexure 1, page 25,
20.
Page 25.
my lord. I have also challenged these terms, my lord, particularly clause 9, I have also challenged this term.
So which clause was applied in your case?
9.3. If the buyer cancels the order rate after booking, the EMD at the rate of such and such shall be forfeited for the order rate cancelled. And also 9.2, they say clause 9, but 9.2 also maybe. Because the fact that is coming before this honorable court is that the successful bidder did not leave the booked quantity within the stipulated validity period.
So are all facts admitted here?
Facts are admitted so
No,
far as that.
see, this is a question we expect you to answer with some responsibility. If there is any disputed question of fact, no relief will be granted.
That's right.
So after hearing the matter for 1 hour, if we find that there is a disputed question of fact,
My lord,
that amount has been lifted or not lifted, then what will happen is the matter will be referred to the
I
appropriate
understand.
forum.
I understand.
Therefore, at the beginning, the question that has been posed, are all facts admitted or there are disputed questions of fact?
So far as the EMD is concerned, it is admitted fact. So far as not lifting of the coal is concerned is an admitted fact. The only dispute that arises to be asserted after what they have said in the affidavit in opposition also,
Hmm.
that whether my cancellation was legal or authorized. And secondly, they say that whatever coal you had, you were bound to lift it. If you do not lift it, it is cancelled. You cannot say that it is not a marketable or it is not a quality. That is what is this basic stand which I have understood.
According to you, the coal they gave you was not as per the commitment. And according to them, it was as per the commitment. So the court will have to first decide whether the coal given to you by the respondents met the requirement, the standard which was agreed upon.
To
Can
an-
that be decided on the basis of?
my lord, this as a question, it may not be, this may not be possible for this writ court to decide, but from the circumstances which has given rise to the situation that the rake was cancelled and that same coal where they had actually delivered, from that, my lord, we can draw a very reasonable and strong inference that it was not of that quality. Otherwise, they would not have let it down to someone else at a lesser price. And that same quality of coal, if it was of that grade, it could have been given to my next in line, my lord, next in the list. The next in the list also did not pick up the coal because of the quality. And my lord, within 15 days, I participated in another auction because I wanted coal. My coal was being cancelled because of not good quality. And I participated in the auction and I purchased another rake of coal, my lord, of the grade which I had tendered for the previous auction also, for which I am before this honorable
So
court.
therefore, please show the document from which it is established that they did not give the coal which they were supposed to give. If that fact is not established, then it will be difficult for this writ court to grant relief to you.
My lord, they are also a state, my lord. When
No, that is another matter.
My lord.
That is another matter. These
My
are
lord.
commercial disputes. This court will have to hold that they did not give your client the requisite standard of coal, and therefore they are the ones who contravene the terms of the contract. Therefore, the deduction of EMD or forfeiture is illegal. That is the third premise.
my lord.
First two, if it is in your favor, then only the question of the third. If the first two are not decided or are not decided in your favor, this court cannot declare the forfeiture as illegal. That is the reason I am saying from the documents on record, is it possible for the court to take a view this way, that way? They will have to either say that, all right, we agreed for this, but we are giving you that. And then you have to show that this, from papers, you have to show that what they had offered is of this grade and what was agreed to was of that grade. This is inferior to that. Can you do that from the materials on record?
My lord, In my respectful submission, my lord, I can make an attempt because if I show the bid list, successful bidders list, and from their affidavit in opposition, they admit the fact that it was given to the thermal plant, which takes a quality of lower grade. It does not go for grade 1 steel grade. That 7,500 calcified, which I have said, my lord, that shows the grade of the heat of the coal.
This is the reason why this matter is pending since 2014.
My lord,
Very
actually,
difficult for the RIT court to give a verdict on that aspect.
my lord, this has been pending for a reason that because my money from 2014, 14 lakhs, today's 14 lakhs value and 2014. Yeah,
You are
lakhs.
not appreciating the basic issue here.
My lord.
14 lakhs or 14 rupees, forget that. First, you have to establish from the materials on record that there was a contravention of the condition of the contract insofar as the quality of material, either the quality or the quantity, either of the two, or maybe both, were not in accordance with what was agreed upon. Correct?
My lord.
If there is exchange of documents where this fact is admitted, but it is only a question of interpretation, then we can go ahead. But if there is dispute as to whether this coal was of this category or not, correct, then to establish that you will have to have expert opinion and examine them. They will have to adduce evidence, and if that evidence remain unimpeached, then the court can arrive at a finding that the coal offered to your client was of inferior grade. Therefore, the forfeiture is illegal. That would be the ultimate inference.
My lord.
You are saying first declare it is EMD forfeiture was illegal, and whether the coal was inferior or not, that we'll see later on. That can't
cannot
happen.
be- That cannot
That
be
can't
done, my
happen.
lord. My lord, I understand, my lord. My
Hmm.
lord, from their affidavit in.
That is because this is a penal action taken,
Yes.
and this is a money claim.
My
This is
lord,
money
it is
claim.
not exactly a money claim, if I may. So that is why I have challenged these terms and condition
All
also.
right, you
which is
argue
to-
then,
so
you argue,
argue that-
you
No, I will
argue.
not waste my lord's time also.
No, we have time. No, time is not a problem. But you see, your efforts will go down the drain.
Yes.
Unless with clarity we find that there are documentary evidence to establish that these people are admittedly given you inferior coal. The
No, they-
relief you are seeking is
They
difficult.
have given me, since that quality, since the quality which was available with them was not of the quality that for which we have bid. That is why on my cancellation, they did not give it to the next in line, which is at serial number at, if my lord may see at page 28 of the writ petition. I was at serial number 11 and there was second one in the list at serial number 12. My lord, he had also quoted the same price. If that coal that was available with them was sold to us at 6,500 rupees, why will they give it not to the next person who is also paying 6,500 rupees per ton? And why will they give it? My lord, if my lord does not appreciate this, then perhaps I think I will be wasting my.
There could be any reason why the next man did not take the coal. That doesn't mean that it was inferior.
My lord, they did not say it in the affidavit.
Hmm?
They have not said that in the affidavit. They have not annexed any copy of the quality also which they have sold to the thermal coal, whether they received that price. If they have given it at a lower price to somebody, then my lord, the only inference that can be drawn, my lord, in the report is that it was not of 6,500 rupees quality. That is why you have given it at 4,000 rupees per ton, my lord. That is the only inference in my respectful submission that can be done. The rest I leave it to my lord, my lord. If that inference cannot be done, because why, my lord, it's a public money, public property. They are state, they are not a private enterprise. They are selling that 6,500 rupees quality. What business you have or what authority you have to sell that 6,500 rupees to another plant at 4,000 rupees, my lord? That's a question, my lord. It in my respectful submission, perhaps it can be considered and appreciated before by this writ court also. The rest I leave it to my lord, my lord. If my lord thinks that this is not an issue which should not be decided in the writ court, then it's not a question of whether that quality was available or not available. They being government enterprise, my lord, they have to show as to why this 6,500 rupees was given to a thermal plant at a lower price, my lord. Because thermal plant did not give them 6,500. Otherwise, they would have said it in their affidavit, which they have not said it. The public property being sold, my lord, for the tenders, my lord. Tenders, that is how this on read courts also exercises its jurisdiction, my lord. How can you sell a public property at a lower price when a next bidder who is, okay, let me say that whether buying forfeited or not forfeited is also, let me give up.
So are you saying that the moment they give an answer, matter is over for your client?
My lord, if they give an answer.
That's a very risky track you are taking.
My lord, if
They
they
can
give
give any answer and then the court will have to.
the end answer will not be acceptable to this honorable court, my lord. How can they? They have to give a responsible and justifiable answer supported with the records that this is what at 6,500 they did not take it. And the next bidder I did not give for this reason, and that is why I give it to the thermal plant at the same
See,
price.
Miss Goel, see, please.
My lord. Public property cannot be
I
done
can
by-
appreciate your anxiety, your client's difficulties, but we are in a court of law.
My lord.
We have to address the issues in an objective manner, and
Ex-
which is based on the legal principles, correct? So in a capsule, this whole matter revolves around one issue. Who has violated the contract? There was a contract between your client and Coal India that through this e-tender process, they will supply a certain quantity of coal. You will lift it. The price was determined. The quality, the grade of the coal was determined. But subsequently, according to you, they have failed to give your client the quality of coal which was agreed to, right? And therefore, your client decided not to buy it, and he got the same quality which you wanted, which it wanted from another source.
Next, same
Correct.
source in the next option.
Next option. According to them, they are not admitting it. According to them, they have given the grade which was agreed upon, right? But by failing to lift it, your client has violated the contract. So the court will have to first adjudicate on this issue as to who's the violator of the contract. That is the core issue here.
But there are two other issues which I also take it to be core issues, my lord, since I'm in a writ jurisdiction, my lord. The second issue is that one I just raised before this honorable court framed the first issue, that being a public property, have you sold it in 6,500 itself or more, or have you sold it at less, and why this they are answerable? And third issue is that I have also challenged the provision itself, the terms and clause itself, or particularly clause 9 of the tender document, because my lord, they have a free field without any arbitrary field.
Achha,
my lord, and they
you
can-
argue, but you argue
Even
here
if
the
forfeiture is held to be correct, because perhaps if this honorable court comes to a conclusion that the facts before this honorable court is not sufficient to decide this issue, being a writ court, my lord, but the other two issues remain open, my lord.
what are the other two issues?
The two issues is whether they could have sold this property at a lesser price to
No,
someone else.
these are not issues. That's what I am trying to convince you. This is not the floor of parliament or assembly. They are answerable, accountable. This is only a forum where we'll decide what is the right of your client which has been violated and what is the remedy. Answerable, giving answer, all right, I don't want anything, but they must tell the court. These are not things we'll entertain. What is the right of your client? Your client is aggrieved by the fact that some 13 lakh something in one case and don't know the amount. These amounts have been, according to your client, illegally forfeited. That's all. So this is the right which your client is saying that has been violated. And that issue will have to be adjudicated on the basis of materials on record, on the touchstone of the contract agreement. That's all. Who did what answer they will give, or we are not going into all these things. So if you think that you will be successful in showing the court that it is an admitted position, that the coal offered to your client was of inferior grade, then there is no difficulty in deciding it.
Admitted, they could not have forfeited, my lord. That's why I'm before this honorable court. If they would have admitted, then they would not have been any issue. Then they, according to the clause only, they could not have forfeited. They said if it is because of their purpose, but when I have very strong facts which can demonstrate that they were at fault, and that is why they gave it to the plant which at a much lower price. And in 15 days, that same quality, they are again selling it at a higher price. But if my lord thinks, my lord, that although they are a public
No,
authority,
but
then
thinking,
I rest my case, my lord.
sorry,
If my lord thinks that being a public authority, they could have done it, and this issue cannot be decided here, then I rest my case.
you are again not getting the point here.
I have understood, my lord. I have
Whichever,
understood.
this is a pure and simple commercial dispute.
It's not a commercial
Yes,
dispute,
yes,
my
yes,
lord.
it is.
Otherwise, I would have gone in a suit or maybe in an arbitration
No,
proceedings.
even
But
if,
I'm challenging the clause also, wherein, my lord, they are given this arbitrary powers of forfeiting and not forfeiting, and they need not even give any material to show that, okay, why it is being done. They do not have any responsibility under these terms and conditions. And that is why I am before this honorable court.
you argue, but unless the court finds concrete evidence to show that they violated the contract, granting relief will be difficult.
My lord,
I'm making it very clear to you.
these are the 2 points I'm raising. If but I have material to show that they have given it to someone else who did not pay 6,500, this I have material to show.
Hmm.
And I have material to show that they did not give it to the next in line who was paying the same money. These 2 material I have. I can place this material subject to, and then as it is, it should not be a futile exercise. But
These are the only two materials to
these
show
are the
that
only 2 materials.
you should try it some other time. Very difficult. I'm not convinced. What is your stand in the matter?
They submitted their bid for the coal.
Hmm.
They were successful, but they did not collect. They did not collect that coal.
No, but they are saying you
This
offered.
subsequently. At that stage, the purpose was, market was low in Punjab.
Hmm.
Rainy season, they said price, they won't get the price, so they did not take it. Subsequently, they again participated in second tender.
They lifted the same quality.
Same quality.
There is no arbitration clause.
No, I think there is, but no. No. 10-year-old case. 10-year-old case, and these e-auctions are only one time auction. Each auction.
All right, then we'll hear. But the only thing is, this bench is only for today. Tomorrow onwards, this bench is not available. So you have to conclude it today. Both sides.
Why not fix a date when this bench will be again available? We have been waiting so long also. Yes.
I don't know when it will be
It's a
available.
futile exercise.
Hmm?
It's a futile exercise.
No, she has a
Right.
grievance. It has to be adjudicated. The court has to give an answer this way or that way. How much time will you take?
Mm,
You have one case to decide at the end.
this- yeah, around 40-45 minutes.
And for you, Mr. Ahmed?
I'll have to take certain instruction because of what she said now regarding other issues. Why we sold it to somebody else.
Mm. So I don't want to keep it part-heard. I'm sitting in a division bench. Single bench is only for today.
Let it be, maybe in January also doesn't matter, we'll take a chance.
I have no problem. It's only lingering the matter.
Heard Ms. B. Goel and a counsel appearing for the lead petitioner in both these petitions. Also heard Mr. Hamzad Ahmed Lana, senior counsel, assisted by Mr. A.M. Dutton, Lana counsel representing the Coal India, any Northeast Coalfields Limited, and others. This matter is pending since these matters are pending before this court since the year 2014. The cases were last listed in the month of January 2022. First up, today when these matters are called up, learned counsel for the respondent submits that some time is required to obtain updated instruction in the matter. Considering the nature of issues involved in this writ petition, although this is a very old matter, this court is left with no option but to adjourn the admission hearing by 3 weeks. Register to list this cases again as fixed items in the second week of January 2023. Let us see, suddenly these matters, I do understand that it becomes a little difficult because sometimes these cases you cannot finish off in one day. But you please examine that aspect of the matter. Your case will be on that. Unless there are convincing documents, because writ jurisdiction, as you know, is a summary jurisdiction, it's an equitable jurisdiction. Money claims on assumptions and presumptions are not permissible under 226. 226, there are number of judgments where the law has been settled that if there is a money claim, 226 is not the right forum, except when there is a violation of a fundamental right, something in the nature of right to life, etc. Or when it is an admitted amount. The moment there is dispute, they have disputed your claim by filing affidavit, whatever be their ground, it becomes very difficult at the end of the day for the writ court to take a concrete view. That's the problem in your matter. All right, we'll see.
I'm grateful.
Five.
May I please your lordships? I am appearing on behalf of the petitioners, my lord. My lord, by way of this writ petition, my lord, an impugned order dated 9/11/2015 has been challenged, which was passed by the learned DRT, my lord, Guwahati. In the original application 177 of 2012, my lord. I'll just give a brief background of this case.
Where is the impugned order, page number?
Order is at page, my lord, 170, my lord.
Hmm.
The impugned order is dated 9/11/2015, my lord. And my lord, since this is a long order, my lord, containing 13 pages, my lord, I'll just draw the attention of your lordships to
So
relevant.
today you are arguing for final disposal of the writ petition.
My lord,
Huh?
if your lordship admits the matter, my lord, we'll go for hearing.
Basically, well, the dispute is like the power of attorney which was placed on record. And an application was filed, my lord, for adducing the secondary evidence. That is the only question before the lordship. This matter is pending, well, the DRT has passed the final orders and recovery proceedings are. There is no stay order.
So this has to be finally decided. We'll continue, but I'm not making this matter part-hard. If it is not completed today, then I don't know why suddenly a half-day bench, this old matters have been given, all for hearing and disposal. How do you, I have to understand the matter.
Yes, sir. If your lordship admits this matter, it will come for hearing, my lord.
Are you agreeing to the?
No, my lord, it's better, my lord, if it can be placed.
Then you have to argue. You argue, we'll see.
Yes, your lordship.
Yes, you argue.
May I please your lordship? So may I give a just brief background of this case, your lordship? An original application was filed by the respondent number 1 and 2, my lord. We have appeared, we filed our written statements also, petition number 1 and 2, my lord. Now the petitioner, they have filed their evidence on affidavit, my lord. We filed our counter evidence, my lord. At the time of final argument, my lord, they filed 3 applications, my lord. 3 applications. One was filed for amendment of the original application, my lord, with respect to the date of the general power of attorney, my lord. Second application was filed for production of documents calling originals from the petitioner number 1 and 2, my lord. 1, otherwise 2, my lord. And third application on the same date was filed for giving secondary evidence, my lord. Now, the question arose before the learned trial court, my lord, was that whether there are two questions, one of fact, in whose possession the general power attorney is, my lord. And second question of law was there before the learned trial court, where at the time of final argument, my lord, whether an application can be adjudicated for secondary evidence, my lord, when both sides have concluded their evidences and everything, my lord. Now, my lord, once that application was filed, my lord, amendment was allowed, my lord, and two applications which were filed, one for production of document
No,
and
after
secondary
the
evidence
matter was,
withdrawn.
hearings, evidence was recorded.
Evidence
Then
was filed.
some
counter
party, your part, who filed the application?
application was filed by the bank, my lord,
Bank for secondary evidence.
for secondary evidence as one part, and my lord, and another application for production of document also, my lord.
That means they wanted to lead more evidence.
No, my lord, they wanted already the evidence which has been filed, my lord. They wanted to adduce through secondary evidence, one general power attorney, my lord.
Oh, that means they wanted to adduce evidence.
Well,
Secondary evidence is also evidence,
yes,
huh?
yes.
So they wanted to adduce evidence
Evidence.
after the recording of evidence was over.
Yes, your lordship.
Correct.
Yes, your lordship.
Whatever the evidence, that we are not concerned.
Yes, your lordship.
Then what happened?
My lord, both the applications were withdrawn without liberty, my lord, by the bank. Now, what happened, my lord? An order was passed wherein both the applications was withdrawn by the bank, my lord. Now, on the next day, again they filed similar applications on two same grounds, my lord, saying a bit different here and there, my lord. Filed again same applications, my lord. Wherein again the petitioner number 2 was called upon to produce the document, which he denied that he do not have the possession of the document, my lord. Now the bank also filed a secondary evidence, so learned trial court allowed their secondary evidence and did not adjudicated the first application. Without adjudicating the first application for production of document, only a second application for secondary evidence was allowed, my lord. My lord, being aggrieved by that order, my lord, I am before your lordships only on two grounds, my lord. Whether your lordship, that at the time of final argument, once they have concluded their argument, I was arguing the matter, my lord. When I took the defense that this general power attorney has not been proved by way of primary evidence or secondary evidence, those application came into light, my lord. So at that moment, that can be allowed or not, my lord. One, whether there was any, second, my lord, whether there was any negligence and natures on the part of the bank.
All right, just take your name, please.
S. Sancheti, my lord.
S.
Siddharth
Sancheti.
Sancheti, my lord.
Please take your seat. Let me go through the order and then we'll try to finish it off. Yes,
My lord, the
I'll just go through the order and then. Mr. Bhatra, how this order is under which provision of law this order is sustainable? Can you please?
My lord, at first, one of the defendants, they had admitted
Hmm.
that they have not.
So
disputed
that
the
is
contents of
on the merit of the case.
My lord.
Please understand the issue.
My lord.
These proceedings before the DRT, CPC rigors are not applicable,
My lord.
but the principle is followed.
Is to be
Correct.
followed. My lord, correct.
Now, asking the defendant to produce a document is under Order 11, Order 14, Rule 11. Correct. You can do that if the defendant relies on that document and refers to in the pleading,
Right.
not otherwise.
Right.
You can't say that I don't have an evidence, so you give the evidence so that I can prove my case. That can't be the case of a plaintiff, which in this case is the applicant. That is settled matter, will not even go into that. The lawyer who was conducting the case apparently had made a mistake. So when the mistake was unearthed, was detected, now they wanted to rectify. There are hundreds of ways of doing it. Why are you taking a route which is impermissible under the law? After the evidence is closed, the matter is fixed for argument. Now you want to adduce secondary evidence? How can you do that in the first place? Secondary evidence cannot be adduced unless the pleadings, in the pleadings, the foundation is laid. Then the question is, you can adduce an evidence when your evidence is on, not after your evidence is closed. After the defendant's evidence is recorded, how can the bank adduce evidence? This is a completely, absolutely unacceptable order. We'll set it aside. You have 5 minutes to tell the court whatever you want to say. This does not fit into any principle of CPC. It cannot be.
And Lordship is right, but. my lord,
Others are waiting. We'd like to go into other matters. This is a good enough matter to spend 2 days,
my lord,
but I don't think this matter deserves that. The fact of the matter is, as I could understand, the OA was filed by the applicant for recovery of some amount,
my lord,
correct?
my lord.
Then the bank had led evidence. There were 2 defendants, defendant 1 and defendant 2.
My lord.
Defendant number 1 had issued a power of attorney in favor of the defendant number 2, on the basis of which the defendant number 2 was running the business.
My lord. Correct.
So bank has adduced evidence, cross-examination, evidence closed, then defendant side adduced evidence, cross-examination, evidence closed. The matter was fixed for argument. At that stage, suddenly the bank realized that, oh, I have only given the photocopy of the power of attorney. Original, I don't have it. Who has it? The other side has it. So now ask them to give the original. And side by side, allow me to adduce the photocopy as a secondary evidence. Both these are completely unacceptable under the principles of CPC. You know it.
Lordship is
So
correct.
what can you argue on this? It can't be done.
Yes.
Order 14, Rule 11 cannot come in here. And you cannot suddenly turn back and reopen the evidence. And secondary evidence is not something else. Evidence is evidence. The evidence either turns out to be a primary evidence or a secondary evidence, and its admissibility depends on whether it is based on pleadings and it meets the requirements of Section 65 of the
65.
Evidence Act. What else is there in this case? We can easily hear arguments for 2 days, but I don't think it is worth it.
I'll leave it to your lordship.
We'll ask the
Otherwise,
Learned Tribunal to
Yes.
hear arguments and decide the OA in accordance with law. And
But the fact is, my lord, they have admitted
hmm.
and my lord, they have not, my lord,
So
disputed.
then
the
why do you
contents
want
of the
evidence? If fact admitted, it need not be proved.
document.
Why this, since how many years this matter?
16. Well,
This is totally unacceptable. Yes, Mr. Sancheti, take your seat.
Yes, your lordship.
Yes. Heard Mr. SP Sancheti, Learned Counsel appearing for the writ petitioner. Also heard Mr. R.K. Bhatra, writ petitioners. Also heard Mr. R.K. Bhatra, Learned Counsel representing the respondent bank. Full stop. This writ petition is directed against the order dated 9/11/2015. Mr. Bhatra, as we'll be compressing the facts, please point out if something is incorrectly recorded.
my lord.
Order dated 9/11/2015, passed by the Learned Debt Recovery Tribunal, Guwahati, in disposing of 2 petitions, VIG petition number 855/2015 and 856/2015 arising out of OA number 177/2012 instituted by the respondent bank against the two writ petitioners, full stop. The facts and circumstances of the case giving rise to the filing of this petition, briefly stated, are to the following effect. The respondent bank had instituted OA number 177/2012 seeking a certificate of recovery be passed against the two defendants in the aforesaid proceeding, who are the petitioners in this case, full stop. The respondent bank had adduced evidence before the learned tribunal, and after conclusion of recording of evidence of the bank, the defendant side had also adduced evidence, full stop. The matter was then closed and reserved for argument, full stop. At that stage, the respondent bank, it appears that at that stage, the respondent bank had filed petition number 855/2015 with a prayer that the defendant number 2 be directed to produce the original power of attorney which was executed by the defendant number 1 in his favor, full stop. Petition number 856/2015 was filed by the bank seeking leave of the learned tribunal to bring on record the copy of the power of attorney marked as Annexure 1 to the OA as secondary evidence, full stop. While the learned tribe, by the impugned order dated 9/11/2015, while the learned tribunal had rejected the prayer made in petition number 855/2015, rejected, that part is rejected.
That no direction was given.
There was no order.
Acha. By the impugned order dated 9/11/2015, the learned tribunal had allowed the petition number 856/2015 by making the following observations and directions. Full stop. You quote it from page number 182, double tick.
855 was disposed of.
It was disposed of with no direction.
170.
Full stop. Double tick to double 182 to 183. Insofar as petition number 855/2015 is concerned, the same was also disposed of by the same order without, however, issuing any direction on the prayer made by the applicant bank, full stop. Aggrieved by the order dated 9/11/2015, the petitioners are before this court inter alia contending that the impugned order dated 9/11/2015 is without jurisdiction and therefore liable to be quashed, full stop. Mr. Sancheti, learned counsel for the petitioners, has argued that after the evidence is closed, the learned tribunal did not have the jurisdiction to pass the impugned order, allowing the bank to produce secondary evidence, full stop. Responding to the above, Mr. Bhatra, learned counsel for the respondent, submits that since the petitioners / defendants, given the CPC, had admitted the execution of the power of attorney by the defendant number 1 in favor of defendant number 2, and considering the fact that the original of the power of attorney was not available with the bank, the petition was submitted, which was disposed of by the impugned order dated 9/11/2015, full stop. According to Mr. Bhatra, the power of attorney would have a vital bearing in the outcome of the proceeding, and hence the bank should be allowed to rely upon the same, full stop. I have considered the submissions made by learned counsel for both the sides and have also gone through the materials available on record, full stop. Since the learned tribunal did not pass any order in petition number 855/2015, and the bank has also not assailed the order dated 9/11/2015 on such count. Hence, it would not be necessary for this court to examine as to whether the prayer made by the respondent stroke bank directing the defendant number two, respondent bank praying for an order directing the defendant number two to produce the original of the power of attorney is concerned. What is the sentence you've written? This one? Examine the validity of the order dated 9/11/2015 from such perspective. Full stop. However, whether the learned tribunal was correct in permitting the bank to adduce secondary evidence at the stage of final hearing stroke argument in the OA, the aforesaid aspect of the matter would certainly have a relevant bearing in the proceeding, full stop. It is not, there is no wrangle at the bar as regards the fact that the rigors of CPC is not applicable in a proceeding instituted under the DRT Act. What is the name of that act? Given the act, full stop. However, the provisions of the Code of Civil Procedure is followed in principle, full stop. In the present case, as noticed above, the petition number 856/2015 was submitted at a stage when the recording of evidence of both the sides was closed and the matter was fixed for hearing, full stop. There is no provision in the CPC which permits the court or the tribunal to reopen evidence once the matter has been closed, full stop. Moreover, as per section 63 and 65 of the Indian Evidence Act, there are certain norms which would come into play if a party seeks to adduce secondary evidence, and unless those norms are fulfilled, namely laying the foundation for adducing secondary evidence in the pleadings, the such secondary evidence, even if brought on record, would not be admissible in the eye of law. First up, a reading of the operative part of the order dated 9/11/2015 goes to show that the learned tribunal has allowed the prayer merely by observing that since the photocopy of the document was already available as Annexure 1, hence allowing the bank to adduce secondary evidence will not cause any prejudice to the defendants. Full stop. The above observation, in the opinion of this court, is not correct in the eye of law. Full stop. The learned tribunal could not have permitted the bank to adduce evidence after the defendant has, after the closure of defendant's evidence, and that too for bringing on record a secondary evidence without following the due process as laid down under section 63 and 65 of the Evidence Act. Consequently, this court is of the opinion that the impugned order dated 9/11/2015 is unsustainable in the eye of law. The same is accordingly set aside. The learned tribunal may now proceed to hear the OA and dispose and decide the same on merit. The learned counsel for both the sides to appear before the, both the parties to appear before the learned tribunal on 12/12/2022 and produce a certified copy of this order, awaiting further order from the learned tribunal, fixing the next date of appearance.
May-
Writ
may I
petition
point-
stands disposed of. Yes,
But
please.
may I point out one thing, since there was no stay order,
Hmm.
proceedings had proceeded and the final order has been passed.
My lord, this writ petition was made, my lord, the writ petition was.
You are saying this now.
My lord, I pointed out.
It is an order passed by the Honorable Justice.
What has happened to the OA?
My lord.
OA has been allowed. But there was a, my lord, condition of the order
My lord.
passed, my lord.
There is a condition, my lord, which has been put, my lord, by way of order 8/1/2016, my lord. The
Have you
pendency
challenged
of-
that order, final order?
No.
my lord, that final order is made subject to
All right,
outcome
I
of
paid
this
for
writ
my learned
petition.
counsel for both the sides. This matter again after 2 months.
My lord, this.
You should have
but the
said
same
it
is
in the
subject-
beginning.
I thought
Answer.
that This writ petition, my lord, that has been made
It
subject.
has
to the-
become infractions. There is nothing
I
in it.
pointed out, my lord.
You have to
that the
challenge
order
the
has been
main order.
My
There is
lord,
nothing in
because
it.
This writ petition has been made subject to outcome. That judgment is made subject to outcome of this writ petition, my lord.
We'll
I have
admit
not
and hear
challenged.
it in due course. No stay. You proceed and execute the certificate.
My lord,
Heard learned counsel for both sides. It is submitted at the bar by the respondents' counsel that during the pendency of the writ petition, since there was no stay order operating, the learned debt recovery tribunal has finally heard and disposed of the OA
OA.
by issuing a certificate of recovery. Full stop. However, the said certificate of recovery is not under challenge in any proceeding. Full stop. Be that as it may, after hearing the submission of learned counsel for both the sides, this court is of the opinion that this issue, this writ petition still raises some issues which would require detailed hearing. Full stop. As such, admit the writ petition. Since the parties are already represented, no formal notice is required to be sent. In this case, registry to list the matter for hearing in usual course. Yes.
my
Item
lord,
6.
by order dated 8/1/2016, my lord, I just read that.
What
order.
did you want? Admission of the matter? It has been done. What else do you have to submit now?
Item 6.
I'm extremely sorry, my lord, if I could not make. lordship
Oh, yes,
aware.
yes, it was pointed out.
I pointed out, my lord, because I
That's
told.
all right.
I'm extremely sorry, my lord.
It's all right. No problem.
Item 6.
Yes, Mr. Monta.
My lord, this is a matter relating to the release of the, my lord, the certain amount of rupees 5 lakhs, which was my lord, on failure of the OTS. And that was deposited in pursuit of the, my lord, order passed by the recovery officer for the precondition of the OTS, my lord. And that to the property is already been sold in the auction on 11th of this month. And it is recovered amount is more than, my lord, the 1 crore and something. It is much more than, my lord, the amount issued in the certificate. So, my lord, the initially recovery officer, my lord, has given a condition that in a precondition condition that if I deposited 5 lakhs, then my OTS will be, my lord, the bank will consider. But that was failed. After that, I filed a petition for releasing the amount. That direction was given to release the amount. Then subsequently, the bank has filed another application that not to be released that amount. And that was deposited with the bank in the interest bearing account, but no lien account, my lord, no lien. And it is subject to the condition that the interest amount will be adjusted against the interest of the, my lord, certificate amount. Now the property is sold. So, well, 5 lakhs rupees that is being deposited, but on the basis of the assurance given by the recovery officer, that is been passed. And then again revisit the order and review that was the order was one cancelled.
Where is the other side counsel?
Others, the name is there, my lord, but it is not present.
Do you have his phone number?
My lord.
Do you have his phone number? The other
Phone
side
number right
counsel?
now, I don't have, my lord, but the.
Why is he? Huh? You are there?
No, your lordship, it's Sandeep Chamaria is there.
You have his phone number.
Number is, your lordship, I mean.
You tell him the court is taking up this matter and disposing it off.
Right.
If you ask him to
Yes,
come
sir.
immediately,
Right.
you wait for some time.
Yes.
Item 7.
May I please your lordship?
Yes.
This petition I have filed for cancellation. My lord, here, my lord, the circle officer has cancelled mutation application, my lord.
Hmm.
Which, my lord, in the year 1997, my lord, the petitioner has.
Circle
purchased
officer has cancelled your mutation.
Mutation application, yes. my
You have
lord.
challenged that in the writ petition.
Yes, my lord. Actually, my lord, what happened?
Why? We will not entertain this. These orders are appealable, the settlement. You have to go to the right forum. Why writ petition?
Actually, earlier also I have approached before this honorable court, and honorable court has directed the concerned authority to consider the prayer of the petitioner. And thereafter they cancel the.
No,
Mutation
earlier might be different, but now the circle officer has cancelled your mutation.
Yes, my lord.
So, what is the reason? What is the ground on which it has been
Ground, my
cancelled?
lord, one litigation is pending before the learned civil court, my lord,
Hmm.
and therefore. they
Over
have
the same land.
Over same land, but my lord, in 3 plots of land, there is no such litigation is pending. I have annexed here non-litigation certificate also in my affidavit in reply, my lord. But my lord.
So
the
we don't
certificate-
understand why you have not availed the appellate remedy here. There is an appellate remedy under the land revenue regulation, is it not? We can't hear these matters in half an hour. Unnecessary, these writ petitions are being filed. Hmm.
Earlier, my lord, order is there, my lord.
Where is the order? Let us see.
Order is that, my lord, page 59.
Page
59. 59.
Yes.
May I read it, my lord?
Yes, please.
The petitioner, page number 60, my lord, relevant person.
Yes.
Petitioner claims to be the absolute owner of a plot of land measuring so and so, covered by DAC number so and so, situated at village so and so, Assam. The name of the petitioner was mutated in the year 1999 from the sale lead number so and so, and patta was issued. The petitioner again purchased the adjacent plot of land in the year 2001. It should be 2010, my lord, from the co-patters. Sale leads were executed after due permission from the Deputy Commissioner, Kamrup District, and the Guwahati Metropolitan Development Authority. Thereafter, the seller and had handed over the right title and possession to the petitioner immediately. The petitioner thereafter applied for mutation in her favor before the respondent number 3, and also for the correction of land records in place of the sellers in the year 2014. Accordingly, the petitioner has filed the following mutation case, that is so and so, so and so, so and so. The grievances of the petitioner before this court is that the said mutation cases referred to here in above are yet to be disposed of by the respondents. After hearing the learned counsel for the parties and on consideration of the facts and circumstances of the case, this writ petition is disposed of with a direction to the respondent number 3 to consider and dispose of the mutation cases filed by the petitioner within a period of 2 months from the date of receipt of this copy of this order. The petitioner is given the liberty to furnish the certified copy of the order of the respondent 3 with the above direction and the observation the writ petition is disposed of.
So there was an application for mutation.
Yes, my lord.
So why are you saying it has been cancelled?
Yes, my lord. It is that, my lord, page.
Where is the impugn order?
Cancellation. Yes, my lord. Cancellation order is. at
Where is the
page-
impugn order?
My lord.
Impugned order,
Impugn order. Yes,
where
my
is
lord.
it?
It is at page 86, my lord. It is in vernacular, my lord. Type copy is there.
Where is the type copy?
Type copy is at 78. Order dated 1/4/16, passed by the circle officer, Dispur Avenue Circle. Applicant so and so. Applicant so and so, so and so, by virtue of purchase of land measuring so and so, so and so, has applied for Namjari, which is situated at so and so, so and so, so and so. In this regard, the Honorable High Court by this order dated 9/10/15 passed in WPC number so and so has passed an order and directed to consider and dispose of the Namzari cases. In regard, Lat Mandal has submitted a report stating that there is some dispute regarding possession and case number so and so are pending before a learned municipal court. It should be civil court, madam. And there is dispute regarding possession of the land as per the rule Namzari cannot be granted in the land. Therefore, by dismissing the application, the Namzari case is closed, my lord. But my lord, in
Yes,
my lord, page 87, my lord. My lord, page 81. This applicant is Nikunja Pathak, but in his name there is no such litigation pending. And other two names is there, my lord. One is Gautam Bhadra and Ashish Datta. And herein also no case, no such case is pending, my lord.
so where is the Latmontal report?
Last Mandal report, my lord. Last Mandal report has not annexed, but my lord, Lordship may kindly peruse to page 67, my lord. This report has been submitted by the circle officer himself. Herein it is specifically stated that whether seller is recorded pattadar owner, yes. Whether seller has possession over the land flat to be sold, yes. And all this report has been filed before the deputy commissioner in my favor, my lord. And after submitting this report, they have cancelled my Namzari application stating that some cases are pending before the court.
Okay, you place your case then.
Yes, my lord. My lord, petitioner has purchased this. Initially, she has purchased one katha 8.5 lesa in the year 1997. And my lord, after getting the necessary sale permission from the deputy commissioner and GMDA, she has executed 5 sale deeds in her name, my lord, in favor of the petitioner.
5
And-
sale days, 5.
5 sale deeds.
Hmm.
No, initially 2 sale deeds. Thereafter, some pattadars, they are also willing to sell their land. And thereafter, after getting the sale permission from the GMDA and deputy commissioner, she has executed 5 sale deeds. And 3 other co-pattadars, they are also willing to sell their land, but as their name was not mutated in their name, so sale permission was not granted. Therefore, they have executed 3 separate agreement for sale and power of attorney in favor of the petitioner. Thereafter, my lord, what happened in the year 2011, petitioner has came to know that some unscrupulous persons, they have illegally executed some sale deeds in respect of the petitioner's land, and therefore petitioner has filed one title suit before the learned civil court for cancellation of those illegal sale deeds. And on that, in that writ petition, my lord, learned court had passed injunction order restraining the defendants from entering into the petitioner's land, and the opposite parties were directed to maintain status quo. Thereafter, petitioner has immediately filed a mutation application, but my lord, 3-4 times, my lord, the revenue staff has misplaced their application, and therefore petitioner has approached this honorable court, and honorable court has passed that order, my lord. My lord, the circle officer has filed report, my lord, before the deputy commissioner stating that the land is still in the possession of the seller. It is this report was filed before the deputy commissioner in the year 2010, 27/9/2010. It is at 65 page number and exer 9. Type copy, madam. The name of the father's name of seller, father name so and so. Whether sale is recorded pattadar owner, yes. Whether seller has possession over the land, yes. Complete schedule of the land so and so, classification so and so, and there is no riot.
And thereafter, my lord, after verification of all reports, my lord, and after verification of Latmangal reports, the deputy commissioner has issued the sale permission. But my lord, in spite of the honorable court order, my lord, the circle officer has rejected the petitioner's application. And my lord, those land wherein no litigation is pending, that application also rejected by the circle officer. My lord, Lordship, may kindly peruse through my affidavit in reply filed on 24/6/2020. I have filed non-litigation certificate. Page 10.
Yes.
Here, my lord, name is Sri Nikunja Pathak, so and so, so and so. Here, my lord, they have executed power of attorney in favor of the petitioner and agreement for sale also. And no litigation is pending in this court against the name of applicant covering the land schedule mentioned in this application with effect from so and so, so and so. And that case, the title suit is still pending, my lord. It is in evidence stage, my lord, process going on. My lord, non-litigation certificate has been issued in this case. So at this stage, my humble prayer is that, so Lordship may kindly set aside the order passed by the circle officer, since there is no case pending in this particular plot of land, my lord.
Which is the particular plot of land?
Here, my lord, petitioner has executed power of attorney, that person, co-petitioner has.
Where is it? Where is the application? Where is the application for mutation?
Here, my lord, application, page 57.
Page 67.
57. This petition I have filed before the deputy commissioner, my lord. The Namzari cases are there, my lord. Case number is there, my lord.
No, what I am asking is where is the application seeking Namzari? What is the
Application-
particulars of land given there?
Application, you can not, my lord. But there is no address. Case numbers are there, my.
Hmm?
Case numbers are there, my. Application.
No, but how do we know which land Namzari she has applied for? And because we have to write that this land there is no dispute.
Yes.
Which land there is no dispute?
And in dispute, my lord, that sale did 26 page number. This is the
Page
sale
number
deed, my lord.
26.
Yes, my lord. These are the sale deed in this
No,
land.
no, sale deeds I have seen.
Yes, my
Where is the state, where is the application which says that give me Namzari in respect to this land? Where is that
The
application?
report is there, my lord, that circle
So
officer.
sorry,
report.
I would have allowed the petition. You don't have the materials. How do we write out an order?
Namzari case numbers are there.
Case number, how do I, then I'll have to go and find out from the case record. What is your case? Come back to the court and
And
write an order.
names are there, my lord, that assists the top, that cancellation order.
No order can be passed. You have to give me the particulars, na, to write out an order. Yes, Mr. Hendrik, what is your stand?
Lord, in our affidavit, my lord, we have stated that not due to the pending of the title suits, my lord, that cannot be.
Pending title suit, so what?
Regarding. My lord, they have to ask.
Who is in
my-
possession of the land?
My lord, as per the my lord, the affidavit, the petitioner has failed to confirm her physical possession of the land.
Now, how will she
Still we are
confirm?
in position.
My lord, they have to ask us that submit some document. That was not being, my lord, submit.
What document will show physical possession?
Regarding, my lord, that land.
What is the name of the document? Tell us.
That is, my lord, not stated in my affidavit. Lord.
No, but you have to tell us, you want the document, you have to say that this document I want. What is that document?
My lord, that regarding that, my lord, nothing has been mentioned in my affidavit. Lord.
The petitioner does not mention mutation is sought over which land. The respondent does not say what document is required. Only state is some document.
Para 10 statement,
Para 10 statement.
para 10 page 7. my lord.
What is there in para 10? Namjari case number.
Yes, ma'am.
What do I do with Namjari case number?
These are the application, my lord, application number, my. And in serial number 5, 6, 7, and 8, there is no such litigation pending, my lord.
That is connected with which Namjari case? Which Namjari case is connected with land where there is no
My lord,
litigation?
Namjari case number 1217
Hmm.
oblique 2014-15,
Hmm.
1218 2014-15, 1219 2014-15, and 1220 14-15.
So where is that statement in the writ petition?
Statement, my lord, I have in my affidavit in reply, my lord.
So Mr. Bhattacharya, these are very simple problems. People work hard to make it so complicated. The petitioner will not give the facts which are required. The respondent will not give the answer which is required. And that is how these matters go on dragging for years and years and years. The simple matter which can be solved. Tell the circle officer to come tomorrow at
My
2
lord,
o'clock.
if my lord directs the petitioner, my lord, to produce the copy of the application for that mutation, along with a copy of the plan, that will, my lord, clear the whole issue. If those plot of lands are not subject matter of title suit, that one rule also will allow the writ petition.
That's what I was supposed to do it. I was about to do it.
Yes,
But
it is for the
then
petitioner, my
I
lord.
couldn't even
Yes.
imagine that these minimum particulars will not be there in the
Lord,
application.
can they come to please, my lord, can
Let
they
them
come to
produce a
page,
copy of the plaint and my lord, those.
page 3 of,
petition.
page 3 of my
Clear
affidavit
the
in
issue.
reply. Page 3 of my
three.
affidavit
Yeah,
in
that
reply. Actually, what happened, my lord? 3-4 times they have misplaced our records, my lord.
At least you should have made that statement in your writ petition. You have given the list of Namjari cases. How is the court supposed to know which Namjari case is pertaining to which plot of land?
Here, my lord, these plots are non-encumbered, my lord, these are given.
So you understand the lapses.
Yes,
Do
my
you?
lord, yes, my
You
lord.
correct it? You
So,
correct
also,
it.
may kindly
Hmm.
allow me to file one additional. letter.
Yeah, you file it. On the request of Ms.
Goswami.
P. Goswami and Mrs. P. Goswami, counsel for the petitioner. This matter be posted again after 2 weeks so as to enable her to bring on record an additional affidavit. Laying down the particulars of the lands, plots of lands involved in the respective Namjari cases. First up, the learned departmental counsel to also obtain instruction on the additional affidavit on or before the next date fixed. Mr. J. Handy, learned, who is government advocate?
Lord, I
Mr. J. Handy, learned government advocate Assam, and Mr. R. Bhattacharya, learned standing counsel, Revenue Department Assam, are present on behalf of the state. These are matters which can be solved in
yes,
5
my
to 10 minutes.
Lordship may also direct the petitioner, my lord, in the additional affidavit, let them incorporate a copy of the plaint in title suit. That will cleanse the issue, my lord.
No, is that you do it? The
Title suit
more,
130, what is there, we do not know.
more casual you are in your approach, the longer time it will take in disposal of these matters. These are land matters. You can throw papers at court. But we will not pass orders unless we know what is the clarity. Sorry. Yes,
I'm obliged. Made lordship. Lordship, in this case, lordship, readings have been exchanged, lordship. Only one thing, lordship, is some recent development of there, which happened on 15/11/22. I may be allowed to bring the same on record, lordship.
you have to.
I may be allowed to bring the same on record, lordship. A decree, my suit was decreed, lordship, by the London Civil Judge on 15/11/2022, lordship.
Yes, what do you say, Mr. Sharma?
Your lordship, my original application has been decreed in the year of 2015.
So you bring both of them on record?
Yes, it is on record
On
in the
record.
writ petition itself at page number
Okay.
121.
Mr. S.
On
Chakraborty,
15
learned counsel for the petitioner submits that during the pendency of this writ petition, the suit filed by the petitioner has been decreed on 15/11/2022, and therefore he be granted 3 weeks' time to bring the same on record by filing an additional affidavit. Mr. M. Sharma, learned counsel appearing to the bank is present and is present, full stop. On the request of Mr. Chakraborty, let this matter be listed again after 3 weeks, so as to enable him to file the affidavit.
Your lordship, I am for only respondent number 6 in this case.
Respond number, who is for the other respondents?
That is the private, that one is State Bank of India, 2 is State Bank of India, number 3 is the
None
private
has
respondent.
appeared, respond number 6, none has appeared for the other respondents. Yes, somebody wanted time in this case.
I respondent 12.
Respondent number 12.
12. Jai Barboya.
What is this matter, Mr. Goswami?
Matter is also, originally, there is a 145 proceeding.
Hmm.
145 proceeding, my position has been declared. Thereafter, he filed revision before the session court, that was dismissed. Thereafter, he approached the honorable court, that was dismissed. Thereafter, he filed title suit dismissed. Appeal file, appeal dismissed. Thereafter, lordship, second appeal was withdrawn with liberty to approach the deputy commissioner under the act. And thereafter, lordship, approach this court and approach this court.
My lord,
Hmm. Yes, you are appearing for?
I am appearing for respondent number 10 and 11.
And what is your claim?
my lord,
No, what is 10 and 11? What is your claim?
Lordship, land, some lands were acquired by the government under this ceiling surplus land. That's what thereafter land has been spent with the tenants. Remaining land has been allotted to some person. I have been allotted some person land by the authority as per settlement policy, land settlement policy. I'm possessing the land. And he has filed a suit, originally 145 proceeding that was dismissed. Thereafter revision dismissed, appeal dismissed. His allotment has been, he has already sold to respondent number 12.
Hmm.
His land has been, what has been settled in favor of him, that has been settled to respondent number 12.
What was the suit for?
Suit for declaration of title claiming that I'm a tenant under him.
That suit has been dismissed.
Dismissed.
The first appeal also dismissed.
Dismissed.
Second appeal,
Second appeal here, at the time of admission, Lordship has passed an order. The liberty is withdrawn with liberty to approach the deputy commissioner.
is that order on record?
because, yes, that order is. Page 92, my lord. That we have done later on. Apart, later. Page 92, election.
So after this order, what has he done?
He has, according to him, he has approached the deputy commissioner
Hmm.
and thereafter he has approached his son report. The deputy
The
commissioner
deputy
has not
commissioner has
responded.
not passed any order. In
No,
the meantime, under one
no.
forty-five CRPC,
Approach the deputy commissioner by filing what? Where is the application?
and Annex 10.
Page number,
Page 94 onwards.
page 94.
His claim is, Lordship, his claim is, as per the Tenancy Act, which is under the position of the tenant should be settled. As per that act, 1 bigha land has been set in favor of him, Lordship,
Hmm.
along with other tenants. Thereafter, he is claiming other lands. He has, what he has
No,
got,
no.
he has already sold to respondent number 12.
No, that is not the affidavit of the
Already a civil
government.
case was filed with respondent number 12 and that is, Lordship, suit was decreed.
Oh, this is confusing. Government has filed its affidavit. We have allotted 8 katas of land.
He is appearing for the
Lordship.
private.
Then how I can, without cancelling my allotment, how arbitrarily at the instance of somebody else who is not a non-occupancy tenant, my lord. This is a clear direction of the Honorable High Court in RSA also. That there is a civil suit is bar. It is not that easy. Without cancelling my allotment, how at the instigation of private respondent 1011 who has not even filed affidavit, I have not got the copy also. But government in their affidavit has stated categorically that 8 katas land is filed. This is our allotment letter. So how, unless and until we have violated some clause without cancelling my allotment, how can be
So have
evicted?
it,
I can be evicted.
you want how many days time?
Lordship 2 weeks.
No. Next
Then-
Monday is fixed item because of his prayer. And respondent number 12 is also short time. I heard Mr. R. Aslam, learned counsel for the petitioner who prays for adjournment in this case
Monday,
on the
let
ground
me
that
see what is the date of Monday.
Earlier, Lordship also heard this matter, thereafter, Lordship, another court.
Oh,
court
yeah,
also heard the matter
full
and
length
fixed the
hearing.
case for a next date. It was not listed before that court.
Se-
It was
7,
Uh,
7 not, let it be on 10th. 7 I have other hearing. Let it be on 13th or 14th December. So that it will be
13. Prays for adjournment in this case by expressing personal difficulty with an undertaking that on the next date fixed, he would not
Good.
seek adjournment. Full stop. Mr. S.K. Goswami, learned counsel for the respondent numbers 11 and 12 have expressed urgency in the matter and prays for an early date for hearing, early date of hearing in this case. Mr. R. Goswami is present on behalf of respondent number 6. Who else is appearing? Mr. R. Bharpujari, learned SC Revenue Department. Assam has appeared for respondent number 1. Mr. J. Hendrik, learned Government Advocate Assam. For respondent number 4, Mr.
SM Hassan for EPDC.
Mr. S.M. Hassan for respondent number
9 Lord.
9 and Mr. You're there? Mr. Gogoi? First stop. In view of the request made by Mr. Goswami and on the acting on the prayer of prayer for adjournment made by Mr. Islam, registry is directed to list this case on 13/12/2022
Yes.
as a fixed item
Lordship.
in the top of the admission column.
Lordship. Diploma.
May I be before Lordship? My lord, very limited prayer, my lord, I am praying for, my lord.
Hmm.
2016, my lord, I spoke in articles at Lanka, my lord, Hochai district under, to be delivered, my lord, at Boxar, Bihar, my lord. And in the meantime, when I approached the responding authority to receive the items which I spoke, my lord, that the items was supposed to be delivered in the marriage ceremony of my sister, my lord, younger sister. So, my lord, that has not been delivered to me. So ultimately, my lord, I have filed number of representation, my lord. So having other option, my lord, I filed this, my lord. petition, my lord, seeking for limited prayer, my lord.
What article you had booked?
My lord, Belang, my lord, bed,
Sorry,
bed. Palang is called
Palang.
Palang. Yes, my lord,
and this is in the railways.
my lord,
You
railway,
are
my lord,
appearing for the railways.
my lord.
Oh, he wanted to give it to his sister, the marriage. What happened?
My lord, actually what happened, the person at Lanka, they did not know that parcel office at Buxar has been closed down.
Hmm.
So it was delivered to up till Buxar. Thereafter, since there was no parcel office, it was returned back.
Hmm.
On its way, my lord, it got lost. That's the admitted fact.
Hmm. So now what do you want?
My lord, may
They are ready
pass
to
in
pay
a
the
appropriate-
compensation, my lord. But
appropriate
as per
order, my lord.
rules,
Why don't you sort it out? What direction you want for this?
my lord, actually, as per rules, my lord, he will get like 50 rupees per kilo that has been booked.
No, my lord,
All total, there were 320 kgs,
my lord,
the weight of the consignment.
my lord, I'm not on section
That comes
13.
to around 16,000 rupees.
16,000.
Right.
How much you want?
My lord, I'm not on that section, my lord. There is a section 13 and 16, my lord, of the railway act. I'm not on that. I'm, my lord, my lord, what I'm trying to project is section 93 and 5, my lord, kindly see.
Hmm.
It is the duty. Once they receive my article, it is the duty to my lord to hand over me, my lord. My lord, their action. Annexer, my lord, I have annexer 3, my lord. What they said, all parcel articles receiving and the handovering is closed. So we cannot give you. Once they receive my articles, at that time of booking, they should have said, no, we cannot receive at this stage. Now they have received it and now they are saying, no, we cannot hand over to you. All are closed. That was the digit, my lord, and negligence, my lord. That's what, my lord, otherwise, my lord,
He's
money may not be
admitting,
everything, my lord.
he's
I have
admitting
lost
that,
all my status, my lord.
he's admitting that there was a
Yes,
mistake.
no dispute, my lord.
Listen,
Because at that point
Mr.
of time, my lord, the
Huh?
circular which was issued stating that the office at Buxar was closed, that was not available with the railway personnel at Lanka.
So
that's
that-
the
whatever,
reason
it
they
is a
had to
railway
speak, my lord.
mistake.
It is, my lord.
It's a mistake on the part, you are admitting.
Admitted in negligence.
So they are admitting their mistake.
Yes, my lord.
It's not that they are contesting. Now, after so many years, the palang is gone.
Palang is gone.
Marriage is over.
Ultimately, my lord, we are very unfortunate, my lord.
That's right.
Yes.
That you are right. But what to do? Sometimes some unfortunate things happen. But why don't you take the compensation as some consolation and close it off?
My lord, as lordship.
What else can be done? Sometimes
Yes.
you have to be reasonable also,
Yes, my
is it
lord.
not?
As lordship.
You feel bad when these things happen. But sometimes,
Otherwise, the manner and the conduct in which they reply or treated, my lord, saying that, oh, yes, I have this book, my lord, it is in my custody. Why I'm refusing to hand over it? That was my grievance, my lord. On other aspect, what I'm projecting, my lord. They should have hand over me. What is the problem for handovering this items which I
where is
see?
the article? It is destroyed.
No, my lord, that was lost, my lord. When it was returned back from Buxar, on the way it lost and they don't have any
But
information
from
regarding that, my
railways,
lord.
accepting these answers are very difficult.
My lord,
How
that's
can it
the-
be lost like this?
my lord, that is the instructions I have, my lord.
Lordship may anyway, lordship may pass any appropriate order, my lord.
You pay him the compensation.
Well, that we have already admitted here that we are agreeable to paying the compensation, but it would be as per section 10130, my lord, or as per the commercial.
So he says the
And
value of the
number-
bed is 1,63,000.
Not
Huh?
much.
But actually, like while booking.
What does your client do?
Lord,
I cannot afford a bed for 1,63,000. What does your client do?
My lord is just small, my lord, laborer, my lord,
Huh?
small laborer, my
He's a
lord.
small laborer.
Yes, my
He's gifting a bed to his sister, which is what?
lord. Yes,
1,63,000.
yes, my lord. It's a hard-earned money, my lord, actually. It's small amount for other person, my lord.
Oh, Mr. More, that's the problem here. Somebody is not honest here. Somebody is not honest.
My lord, it's a hard-earned money, my lord.
Oh, hard-earned money.
And my lord, that's why otherwise, my lord,
How many How many beds have you seen which are worth 1,63,000 rupees? And that too, you are talking about which year? 2016,
My lord, it's a,
8 years back.
it's a first class tick, my lord,
Huh?
first class vote and
First
tick.
class tick.
Vote and
And
tick.
what other items he has given to his sister?
My lord, this, my lord, annexure one is the
Hmm.
items. And in the affidavit, my lord, it is here, my lord. The,
Your client is not genuine, he is not honest.
my lord, whatever, my lord, I am not on that, my lord, whatever may be, once I hope, my lord, it is their responsibility to, my lord.
No, that you are right, that you are right. Where is your client has made it himself or he has purchased it?
That part of, my lord, I
You
have
don't
not instruction, my lord.
All right, then you pay him compensation as per the rules. Do it within 15 days from the date of receipt of a certified copy of this order.
Right.
Failing which the amount will carry interest. Take down. Mr. Murray, take some compensation and
My lord, yes,
tell your client to forget the episode. I should take down heard Mr. N.K. Murray, learned counsel appearing for the writ petitioner. I have also heard Mr. Burkoti, learned standing counsel, NF Railway, appearing for the official respondents. Full stop. This writ petition has been filed by the petitioner being aggrieved by the failure on the part of the NF Railway authorities to deliver the goods sent by him due to their failure to deliver the articles booked by the petitioner through railway freight. Full stop. It appears from the pleadings that the petitioner had booked a bed, BED, wooden bed at Lanka railway station, Lanka, for delivery at the Buxar, BUXAR railway station at Bihar. Full stop. The bed was meant to be gifted to his younger sister, whose marriage was to be solemnized, on 18/4/2016 at Buxar, Bihar. Full stop. However, since the railway authorities had failed to deliver the wooden bed at Buxar, the petitioner had lodged a complaint and thereafter lodged a complaint before the railway authorities and thereafter came to know that the article was misplaced by the NF railway authorities. Full stop. Being aggrieved by such conduct of the railway authorities, the petitioner has approached this court by filing the instant writ petition. Full stop. Mr. Murray submits that apart from the sentiments of the petitioner involved in the matter, he is also highly aggrieved in the manner in which the NF railway authorities have treated the petitioner by even refusing to hand over back the undelivered goods. Full stop. Responding to the above, Mr. Borkotaki submits that after the article was booked at the Lanka station, it came to light that by a circular issued by the NF railway authorities, the Buxar loading station, is it?
Parcel office, my lord.
Buxar parcel
Parcel
office had been closed down. That is the reason, full stop, that is the reason the article could not be delivered at Buxar, full stop. However, when the parcel was being returned back to Lanka, the same got stolen en route, as a result of which the possession of the booked article would not be handed over to the petitioner. First up, by admitting that there are some lapses on the part of the NF railway authorities in this regard, Mr. Borkotaki submits that due compensation as per the
My lord, section 327 of the commercial manual as well as section 103 of the railway act, my lord.
just compensation as payable in the matter as per section 3,
327 of the commercial manual.
3 (27),
No, my lord, 327,
327. As per 327 is what? Clause?
my lord. Clause 327 of the commercial manual,
Clause 327 of the commercial manual,
as well as section 103 of the railway act,
read with section 103 of the
railway act, my lord, 89.
Railway Act, would be paid to the petitioner. First up, the learned standing council NF Railway further submits that the compensation payable to the petitioner shall be calculated on the basis of weight
My lord,
of
that
the
was booked,
packet, which was weight of the
Book.
parcel, which
which is reflected in the railway receipt, my lord.
is
Number
reflected in the railway receipt. First up,
Annex A,
uh,
railway receipt, annex A to give unto the-
taking note of the facts and circumstances of the case, this court is of the opinion that
That railway receipt will be annex 1, my lord, of the petition.
full stop. As per the weight mentioned in the railway receipt, which is annexed as annexed
one,
one
The
to
petition.
this writ petition. Full stop. According to the railway receipt, the net weight of the parcel was how many
300
kgs?
328 kilos.
328
8.
kilograms.
320, my lord.
320, why are you saying 28?
I'm sorry, my lord, 320.
320 kgs. Full stop. Full stop. After hearing the submissions of learned counsel for the parties, it is apparent that there is no dispute about the fact that the petitioner had booked the article for delivery to his sister on the day of her wedding. Full stop. If there was no parcel handling station at Buxar, then the article in the first place should not have been accepted at all by the NF Railways. Full stop. Even if the same is accepted, comma, the undelivered parcel ought to have been handed over to the petitioner, which was also not done in this case. Full stop. Therefore, it is a case of serious negligence on the part of the NF Railway authorities. Full stop. However, since the petitioner's counsel has submitted fairly that you take the compensation
adequate compensation as per law.
that his client would be willing to accept adequate compensation, and taking note of the submission of Mr. Borkotaki, I dispose of this writ petition by directing the NF Railway authorities to pay him the compensation on account of lost article as per the provisions mentioned above, calculated
Adequate compensation, my lord.
calculated on the basis of
As per law.
actual weight of the article, that is 320 kgs. In addition to the above, for the harassment and injury caused to the petitioner and sentimental injury caused to the petitioner, the NF Railway authorities would pay an additional sum of rupees 25,000 to the petitioner as cost. If the total amount as directed by this order is not paid to the petitioner within a period of 3 weeks from the date of receipt of a certified copy of this order, the amount would carry interest at the rate of 9% per annum from the date of this order till realization. With the above observation, this writ petition stands disposed of.
Much obliged.
Sorry, my lord. I am obliged.
Yes,
I am obliged.
Item 11.
Hello, in this case, talk of compromise is going on. Last week, the bank asked me some further document to settle the matter. Accordingly, on last week, I have submitted all the relevant document to the bank to settle the matter.
Yes.
bank has informed me
Hmm.
on Friday that he will send the entire proposal to his higher authorities
Hmm.
within this week.
Hmm. So you want adjournment?
Yes. And adjournment. The bank-
All right.
Yes.
Mr. T.G. Barua, learned counsel for the writ petitioner, as well as Mr. P.C. Goswami, learned counsel appearing for the
Bank.
respondent bank, submit in tandem that a process of out-of-court settlement is going on in this matter, and there is a strong likelihood that the dispute of the petitioner with the bank would be resolved amicably within a further period of 6 weeks. Full stop. Mr. Borua submits that some documents as called for by the bank has also been submitted by his client very recently. Full stop. Mr.
For the response number 3 and 4.
Mr. A. Chandran, learned GAP is present on behalf of respond numbers 3 and 4. Taking note of the submission of the learned counsel for the parties, this admission hearing of this writ petition stands adjourned for 6 weeks.
Time being matter item 6.
He was informed and he told that he is coming, but he's not receiving.
Let it be day after tomorrow then. Because without him, if you pass an
Must.
order, he will again, on the request of Mr. Mahanta, learned counsel for the petitioner. Now, if first read Mr. M. Mahanta, learned counsel for the petitioner is present. However, none has appeared for the respondent. Considering the nature of issue involved in this proceeding and for ends of justice, this court is inclined to grant one more opportunity to the respondent to appear in this case. Register to therefore list this case again on Thursday, which is Thursday date 30/11, Thursday.
Yes.
Thursday is 1st December. 1st December.
First
Thursday.
For orders item 13.
Yes.
Lordship, this contempt is for non-payment of construction bills, Lordship.
Hmm.
Some amount has already been paid. In the meantime, respondent number 4 is retired, Lordship.
Hmm.
So they have not included the present principal secretary, Lordship.
Some amount has been paid. What about the other balance amount?
Balance amount, that on the last occasion, the petitioner was supposed to take the information regarding the balance amount, which has been paid or not. But even I don't have instruction as of now. Lordship may take it as the money.
None has appeared for the petitioner, Miss
S. Kemprai, Lordship.
S. Kemprai, learned counsel appearing for the respondent number
Respondent number 4, Lordship.
4 submits that
Respondent number 4 retired, Lordship.
submits that her client has in the meantime retired from service on attaining the age of superannuation. First, however, according to Ms. Kemprai, the dues of the petitioner has been substantially cleared. Full stop. Since the petitioner's counsel is absent today, the said submission of Ms. Kemprai cannot be verified. Be that as it may, register to list this matter again after 2 weeks.
Blush, Lordship.
Item 14.
May I please, Lordship? Lordship, not release of contractual dues, my lord, that has been already admitted way back in the year 2012, my lord. By which, my lord, my repetition was already disposed of.
Where is the order which has not been complied with?
Page number 9, my lord. Operative portion of page number 10,
Page number 9.
my lord.
Yes, you are appearing for whom?
My lord, I am appearing for respondent number 6, my lord. My lord, chief engineer, my lord. My
Why
lord,
you have not paid the bill?
No, my lord, respondent numbers during his tenure, my lord, he has submitted an instruction on 29th of October 2019, my lord.
Hmm.
Budget demand proposal for amounting 15,81,678 already submitted to the government, my lord,
Hmm.
for payment, my lord. And And in the meantime, he returned, my lord. Thereafter, my lord, new incumbent is working as a chief engineer, my lord, at present, my lord. And we are not getting the up-to-date status.
Who is the present chief engineer?
My lord, Sanjeev. Sanjeev Shah.
Why have you not employed him?
We have not been, just now we have been informed about him. Till
Can you
last-
give him a copy of that instruction?
Yes, my lord.
Give him a copy. You employed him.
My lord.
Mr.
HK Sharma.
H.K. Sharma, Learned Counsel for the petitioner, prays for and is granted 3 weeks' time to implement the new incumbent in the post of chief engineer. Which department is this?
PWD.
PWD Assam, as a party to this proceeding. Prayer allowed, but you have to first demand compliance and
My-
then come.
My lord. Much.
Mr.
DK Roy.
D.K. Roy, Learned Counsel is present on behalf of the respondent number
6.
Respondent number 6. What about the other respondents?
The
Let's see.
instruction was for the chief engineer, madam.
Other respondents have not appeared.
No, my lord.
Why?
Respondent number 2 was earlier the chief engineer, my lord. Subsequently, respondent number 6 was implemented, who was the earlier the chief engineer, my lord. The chief engineer has.
What
admitted-
about 1, 2, 3, 4, and 5? Who is appearing on their behalf?
Till that, my lord, they had not appeared. Only the chief engineer used to represent, my lord. Because, my lord, the affidavit was filed on behalf of the chief engineer in the my 2012 repetition, my lord.
No, in the contempt matter, they have received notice but not appeared. You are also silent about it. All right. Registry to verify as to whether notice has been served upon the remaining respondents in this case and put upon vote. Next date.
Item 16.
Yes.
I am representing respondent 1, 2, and 3. Affidavits have already been filed. They are required to bring on record, my lord, the new incumbents. These persons have, my lord, way back, long back, they have, my lord. been
Which
transferred.
order has not been complied with? Which is the order of the court?
Yes, my lord.
9, Lordship.
Page number?
9. Okay, the operative part is at page number 14.
Who is to carry out this demarcation?
My lord, the deputy commissioner concerned.
And you are appearing for whom?
My lord, I am appearing, my lord, the first one, my lord, the deputy commissioner, sub-divisional officer, as well as my lord, the commissioner and secretary revenue department. In our affidavit, we have taken a stand, my lord, after passing of this order. My lord, huge exercise was undertaken. And it was found, my lord, it is almost, my lord, 2,188 bighas. Already there are settlements, my lord. In fact, there are government establishments are also there. Now, my lord, in order to evict, my lord, and to, my lord, for proper rehabilitation, my lord, of this, my lord, graziers, professional graziers, my lord, several meetings were conducted. And my lord, some consensus were, my lord, arrived at one point of time, but the matter halted at that, as it is, my lord. Now, my lord, what is the subsequent, my lord, developments, my lord, since I am representing the earlier respondent, they are required to bring in the new respondents, my lord, then only. In fact, on the last occasion, there is a clear
2
order.
weeks time will be given that.
This honorable court has directed.
Mr. M. Basumatari, learned counsel for the petitioner, prays for and is granted further 4 weeks time to implement the new incumbent in the office of Deputy Commissioner Dhemaji as a party to this proceeding. First, Mr. R. Borpujari, learned counsel is present on behalf of respond numbers
My lord, 1, 2, and 3.
1, 2, and 3.
Obliged.
Hmm? 17, yes.
Item 17.
Yes,
Malab, this contemplation again for non-compliance of this order dated 31/2017 has been WPC number 7668 of 2015, Malab. Then, Malab, I have to file a contempt petition which was registered as 359 of 2017. Then, by a common order dated 26/2/2018, and annexer 3 at page 17, Malab.
Hmm.
Relevant page is at 19. The lordship has passed the order that heard Mr. I. Hussain, learned counsel for the petitioner. I have also heard Mr. B. Ahmed, learned counsel representing the respondent, who submit that the petitioner's case has already been examined and matter has been forwarded seeking approval of the finance department for making payment. Dr. Ahmed submit that the payment can be made after the approval of the finance department is received. I find from the record that officials of the finance department have not been included as a party respondent in this proceeding. Since the respondents have already complied with their part of the order and they cannot be held responsible for non-compliance of the court order on the ground of non-receipt of the approval from the finance department. As such, I do not find any justification to keep these contempt cases pending before this court. Consequently, the contempt cases are closed. It will, however, remain open for the petitioner to approach this court by filing fresh contempt petitions in accordance with law. So accordingly, my lord, this fresh contempt petition has been filed by implementing the finance department, the commissioner secretary to the government of Assam irrigation department.
Which is the order you just read, page number?
Page number 19, 11 page. Annexer 3, page number 19. Passed by his lordship.
In the original case, finance was not a party.
Not a party. Only the irrigation chief engineer and the irrigation commissioner secretary of the irrigation department were made party.
Hmm.
This was, since the Dr. B. Ahmed, who is appearing for the finance department, it is already sent to the finance department for approval. So according to the earlier contribution has been closed and lordship also directed to file contribution by including the finance department. Accordingly, this fresh contribution has been filed by filing the principal secretary of the government of Assam finance department and the commissioner secretary of the government of Assam finance department, madam, along with the chief engineer irrigation department, commissioner secretary of the government of Assam irrigation department. But my lord, they have not neither have filed any counter affidavit, neither have they appealed before the honorable court by filing any application. Now,
You
my
are
lord,
appearing.
Lordship, I'm appearing for respondent number 4, my lords. Here, Lordship, regarding the status of the proposal, Lordship, I'm just seeking a short accommodation. By the next date, I'll apprise as to the status of the petitioner's case, my lords, because I've entered appearance for the first time.
All right, Mr.
my lord,
Yuchak.
in the other cases, many analogous matters, my lord, in the last occasion, it is known to us that the officers who is holding this post are not in this post. Now new officers have been in this post. So accordingly, I have been directed to take steps, issue notice, and if necessary, I have to file a petition for implementing the necessary parties. So this order is being managed into the same matters.
All right, on the request of Ms. U. Chakraborty, learned counsel for the petitioner, this matter stands adjourned for 4 weeks by granting her the liberty to file appropriate application for implementing new incumbents in the office of new incumbents who are now responsible for
Yes.
implementation of this court order. Mr. H. Earlier, learned counsel for the respondent number 4 also prays for 3 weeks' time to seek instruction and update and appraise this court as to the steps that have already been taken for compliance of the court order. What's the matter accordingly?
May I appear, Your Lordship? Lordship, this contempt petition has been filed for non-compliance of the order dated 23/3/2018. Lordship will find that at page 8. The effective is at page 9, Lordship. In view of the submission of Mr. Sharma, the petition is disposed of by directing the commissioners of Guwahati Municipal Corporation to verify and examine the claim of the petitioner within a period of 2 months from date of receipt of a certified copy of his order, and to make payment that is found due and payable to the petitioner within a period of 4 months thereafter. So, Lordship, initially the contender number 1 was issued notice on 1/2/2019, and Wakalatnama was filed on 30/3/2019. In the meantime, the person demitted office, and next incumbent was issued notice. He was made party by order dated 30/8/2019. He also demitted office, Lordship. Thereafter, another contender was implemented as party by order dated 28/3/2022. Lordship,
What about the present incumbent? Is he a party?
Lordship, Devashish Sharma was the last incumbent. Yes.
No, I
To
think
my-
so. It has changed
to my-
in further.
Lordship, already 3 persons have demitted office till now.
No, but what to do? This is how it happens.
The Lordship, earlier, the GMC sending council had filed wakalatnamas and he was directed to obtain instruction as to the status. This is a.
Why don't we add the present incumbent then? Demand
Lordship, then,
compliance?
Lordship, then in that case, may I pray for a short day? Lordship will take dusty service because Lordship, again, the same thing will happen. Again, I will implement the next
No,
incumbent.
no, that's
and someone
correct.
else
But
will
in a
come.
contempt case, you can't make a
I
justice
understand that.
service. It's not permissible. First of all, you will have to demand compliance.
Lordship, absolutely, Lord.
If he does not comply with the order,
Lordship,
then only you
absolutely,
can,
Lordship.
that is the problem in contempt.
Lordship, can it be after 2 weeks then, Lordship? In the meantime, necessary steps.
All right. You take down heard, Mr.
M. Das.
M. Das, learned counsel for the petitioner. None has appeared for the respondent. On the request of Mr. Das, this matter stands adjourned for 3 weeks in order to enable him to demand compliance of the order of this court from the new incumbent in the post of GMC commissioner, and thereafter file appropriate application for improvement,
Obliged.
if so advised. If so advised, no, like thereafter. If so-
My application, Lordship, this contempt petition was filed for non-compliance of the order dated 22/3/2018 passed by this honorable court in WBC number 2063/2016, my lord.
Hmm.
What happened, my lord? The earlier writ petition was filed for non-release of the sanction amount, my lord. And the stand taken by the department was that since the proposed
Page number 16 is the my lord direction of the
honorable court has directed that since the amount was lapsed, my lord, liberty was granted to the petitioners to file a fresh proposal, my lord. And direction was issued to consider the same, my lord. And subsequently, the petitioners have filed fresh proposal, my lord.
So this is the order of 2018.
18 my lord.
Then subsequently, my lord, the WBD department has filed their affidavits, my lord. It appears that, my lord, they have sent to the proposal to the finance department for sanction, my lord. And the finance department yet to file their affidavit, my lord. The problem is now that the petitioners and other members who were earlier the members of the Chutia Development Council, they were no longer in the Chutia Development Council. So I am sought for the instruction, my lord. They have failed to give me any.
So there is no contempt here right
My lord.
now. You have to close it and you can seek a fresh direction
Well-
with the finance.
Well,
Huh?
my lord, that is the thing.
We'll close it by
Well-
giving you liberty. Mr. M.K. Sharma, Learned Counsel for the petitioner submit that in terms of the order dated 22/3/2023, the Department of WPT and BC has submitted a proposal before the Finance Department, but the same is yet to be acted upon. Mr. Sharma has therefore, fairly submitted that there may not be any surviving cause in this contempt case. And he be granted liberty to pursue appropriate legal remedy by filing proper writ petition. Full stop. Mr. Ardhar, Learned Counsel appearing for the
Respondent number 5, my lord.
respondent number 5.
Respondent number 3, my lord.
And Mr. H. Alia, Learned Counsel for the respondent number 3 are present. First up, on the prayer of Mr. Sharma, this contempt case stands closed with liberty as prayed for.
I'm obliged.
Item 20.
Yes,
I mentioned it at 2 p.m. my lord.
what do you want?
I'm time, my lord.
Huh?
I'm adjournment. I'm
Adjournment.
taking
You are
adjournment.
appearing for whom?
Pardon?
You are appearing for whom?
For respondent number 2, my lord. On behalf, why the limit?
None appears for the petitioner when the matter is called up. The Learned Counsel for the respondent number 2 has also prayed for adjournment to obtain updated instruction. Although this is an old matter, yet considering the circumstances, the prayer for adjournment is allowed. Let this case be listed again after 4 weeks.
I love it.
Item 21.
In this case, the new incumbent has taken over the office matter now, so they have to implement the new incumbent.
Lordship, we intended to file improvement application, kindly 2 weeks.
Your name, please?
J. Boro.
Ms. J. Boro, Learned Counsel for the petitioner, prays for and is granted 3 weeks' time to file appropriate application for improvement of the new incumbent in the post of
Chairman, Tinsukia Municipal Board.
Chairman, Tinsukia Municipal Board. Full stop. Mr. Gupta, A.K. Gupta, Learned Counsel is present on behalf of.
Only one opposite party is there, earlier chairperson,
Now you are representing whom?
opposite party.
Number,
Only sole.
sole respondent, yes.
Obliged.
Item 22.
May I please, your lordship?
Hmm.
My lord, we have not been able to get in touch with the petitioner. So we request to grant 2 weeks' time.
They are also required to, my lord, implement the new incumbent, commissioner and secretary.
Your name, please?
Ms. K. Burman.
Ms. K. Burman, Learned Counsel appearing for the petitioner, prays for and is granted 4 weeks' time to obtain updated instruction and file appropriate application for improvement of the new incumbent in the office of
Commissioner and secretary, my lord, Government of Assam Revenue Department.
Commissioner Secretary, Government of Assam Revenue Department. Mr. R. Pujari, Learned Counsel is present on behalf of respondent number.
Respondent 1, my lord.
Respondent number 1.
My lord.
Yes.
Item 24.
Yes, please.
Lordship, in terms of this order passing the repetition, Lordship, we have received budget allotment, and on 27/11/2019, we requested the petitioner to furnish his vendor details, Lordship. We wrote so many detailed letters, Lordship, but till now we have not received his reply, Lordship.
None has appeared for the petitioner when the matter is called up. Mr. V. Nayak, Learned Counsel appearing for the
Respondent number
respondent.
2, Lordship.
Respondent number 2 submits that after receiving the budget allocation.
No, in terms of the order passing the repetition, Lordship, we received budget allocation. Thereafter, we requested the
In
petitioner.
terms of the order of this court, the department has received the budget allocation and
No.
thereafter the petitioner was asked to furnish necessary
Vendor details, Lordship.
tender details.
Vendor.
vendor details,
of the petitioner.
but till
now.
vendor details in the month of
27/11/2019.
on
Course.
27/11/2019.
Lordship, I have found here, Lordship, 3-4 letters, Lordship, same letter.
But no response has yet been received from the petitioner till date. Ms. D.D. Burman, learned counsel,
Okay, for referral number 4, 5, and 6.
appearing for the respondent number 4, 5, and 6 has also made a similar submission.
Already, filed. I
Hmm.
think it-
Be that as it may, since the petitioner's counsel is absent today, let this matter be listed again after two weeks, so as to give him one last opportunity to appear in the matter. Failing which appropriate orders will be, consequential orders will be passed.
Item 25.
None appears for the parties. Matter stands adjourned for 2 weeks.
Item 26.
May it please the lordship, as per order dated 27/2/2020, my lord, we need further 2 weeks time to file an IA for impleading respondent number 2, my lord.
On the pair of Ms. R. S. Deori, learned counsel for the petitioner, 2 weeks further time is granted for filing appropriate impediment application.
Obliged.
Item 27.
That's it.
You had some prayer in the morning?
Yes, my lord.
What is your prayer?
After 2 weeks, my lord.
Why?
My lord, here, my lord, it's an interesting case, my lord. During continuation of interim order, my lord, the petitioner has been arrested, my lord, in addition of new section, my lord.
Arrested?
Yes, my lord. My lord, earlier, my lord, the case was registered under section 490A and section 4 of Dowry Prohibition Act, my lord.
Hmm.
On 16/10/2019, my lord, this honorable court has granted interim relief, my lord. So subsequently on 19/10/2019, my lord,
Hmm.
in addition of non-bailable section of 376, my lord, he was arrested, my lord. Here I am representing respondent number 2, my lord, who has my lord, did my lord, Joint Commissioner of Guwahati Police, my lord.
Hmm.
So he take the suggestion from the CGM, my lord, Guwahati, my lord, what to do, my lord, in addition of new section, my lord, non-bailable section, my lord.
Hmm.
Because the ingredients, my lord, found in the 164 CRPC, my lord, is very, my lord, incriminating, my lord. So they decided to arrest the petitioner, my lord.
By ignoring the court order.
No, my lord, in thereafter, my lord, on 1610 itself, my lord, new section of 370 has been added, my lord.
Hmm. So as of now, he is in custody.
No, my lord. Thereafter, he was released, my lord.
Hmm.
So now the petitioner filed this contempt petition for violation of the interim order, my lord. On the basis of a Supreme Court order.
So why it was violated?
No, my lord, we have discussed the issue, my lord, with the then my lord, CGM Kamroop, my lord,
Hmm.
and CGM Kamroop, my lord. So after discussion, it was decided for an addition of new section of non-bailable section, my lord, it can be done, my lord. So it is not a willful disobedience of any order, my lord. Because when they have relied on judgment of Supreme Court, who just passed on 1/7/2019, my lord, Potip Ram, my lord.
So we'll have to examine it. Then.
Yes, my lord.
Let it, Mr. A. Sharma, learned counsel is present on behalf of the petitioner. Mr. S. Bhattakur, learned counsel appearing for the respondent number 2, prays for 2 weeks further time to obtain further updated instruction in the matter. First up, Ms. D.D. Burman, learned counsel is present on behalf of the respondent number 1. On the request of the respondent